Speaker.
As we resume, I recognize the member for Princestown. You have 11 minutes, 55 seconds of your initial speaking time, and then you have your additional 15. You care to avail yourself?
Yes, sir.
So proceed.
Thank you, Mr. Deputy Speaker. Mr. Deputy Speaker, to pick up from where I left off, I was dealing with the advisory committees as contained in the bill. Mr. Deputy Speaker, as is presently presented to us in the NSITT establishment through this bill, what you have happening is the Director General, having been advised by the chairman of the board and the board members, now has that authority to select these ad hoc committees or these advisory committees. And essentially what these advisory committees will be doing is directing the policy. Directing policy with respect to finance, with respect to human resource management, with respect to operationalizing issues that affects the National Statistics Institute of Trinidad and Tobago. Mr. Deputy Speaker, in clause 33 of the bill, the NSITT bill, it blanketly says that the NSITT shall be granted access to data, records, documents, returns, and certificates, whether individual or corporate, in the control of all public bodies, including the NIB and the BIR, from which information is sought in furtherance of the purpose of this Act. Mr. Deputy Speaker, speakers before me touched on this particular issue, knowing that it would be an area of concern not only for us in the opposition, but in many sectors of Trinidad and Tobago as it relates to the NIS and the BIR. Mr. Deputy Speaker, the CARICOM Model Bill explicitly names the CEO. The equivalent in the NSITT bill will be the Director General as the custodian of that data after collection. Mr. Deputy Speaker, I don't think we fully appreciate that point in this bill. In the NSITT bill, it blanketly says the NSITT. And while I understand that the National Statistics Institute of Trinidad and Tobago will be able to designate, this is either very bad drafting or an administrative error, Mr. Deputy Speaker. And Mr. Deputy Speaker, time and time again, you will hear from the member for Diego Martin Northeast and the member for San Fernando West, our people who bring bills to this House in other incarnations because of laziness and not doing their homework, and members do not read. Mr. Deputy Speaker, when you look at clause 33, clearly members opposite did not read. Mr. Deputy Speaker, the CARICOM Model Bill explicitly names the CEO, which is the equivalent of the Director General in the current bill before us, the NSITT Establishment Bill, as the custodian of that data after collection. There's no ambiguity in this law, Mr. Deputy Speaker, with respect to the CARICOM Model Bill. There is no room for ambiguity in the law, Mr. Deputy Speaker. The NSITT bill blanketly says the NSITT, the language should be harmonized in the bill if we are to accept this point. But alternatively, I can already say that there are issues contained in this provision in clause 33 of the NSITT bill that we have serious issues with. Mr. Deputy Speaker, on that point, clarification is being sought with respect to the scenarios in which NSITT would require the personal information regarding returns and tax information on anyone. So any member speaking from the government, we would hope that they will provide the rationale for why this particular clause was phrased in the way that it was, in that there's ambiguity in the law, and what was the real intention with respect to the NIS and the BIR. What would necessitate the National Statistics Institute of Trinidad and Tobago in acquiring this information, Mr. Deputy Speaker? Mr. Deputy Speaker, while I know, and I will put it out front, Mr. Deputy Speaker, that there are other jurisdictions that provide for looking at NIS and BIR, while the provision may be so, it does not blanketly provide this ambiguity in the law with respect to the role of the Director General as opposed to what is contained in the CARICOM Model Bill with respect to the role and functions as a custodian of data through the Chief Executive Officer. Mr. Deputy Speaker, in analyzing the bill that is before us, it was important to take a look at the legislation that established the current Central Statistical Office of Trinidad and Tobago, and to see what were the deficiencies compared to that law to what we are trying to establish, Mr. Deputy Speaker. Mr. Deputy Speaker, the powers afforded to the minister under the NSITT, the powers afforded to the minister in terms of the establishment of the board and the direction that will be given to the board, the powers that are afforded to the Director General is completely different than what is contained in this bill. And while one may argue that the drafters of that legislation, which governs the original CSO bill, may not have taken into context the present-day scenario that we live and operate in, Mr. Deputy Speaker, it was the same purpose in mind to insulate from political interference. There's no mention of the minister in the original legislation as with respect to the CSO. Mr. Deputy Speaker, it says, pursuant to Section 3.2, and I'm quoting from the original CSO Act, Mr. Deputy Speaker, pursuant to Section 3, subsection 2 of the Statistics Act, the director can employ staff and so on at the statistician department only with the approval of the minister. That is the only, and that falls within the realm, Mr. Deputy Speaker, of how the public service operates. But it does not give the day-to-day runnings and direction and policy powers to a minister, Mr. Deputy Speaker. And again, the staffing as pursuant to Section 3, subsection 2 of the Statistics Act would fall in line with the Service Commission and the public service, Mr. Deputy Speaker. Mr. Deputy Speaker, there are other labor issues that other colleagues will deal with if given the opportunity, or if not, I'm sure will be fleshed out in the Joint Select Committee. Mr. Deputy Speaker, I would like to look at other jurisdictions and what other jurisdictions have provided in their law that I believe that can help us further along in terms of where we want to be with respect to the establishment of the National Statistics Institute of Trinidad and Tobago. Mr. Deputy Speaker, very early I did indicate that within the CARICOM region, there are some countries that have not advanced their legislation and is still governed by old law. 1960s, 1970s, the most recent one, as I said, would have been in 2006, that I could have found with respect to Belize. But, Mr. Deputy Speaker, what you have seen happening in countries like Jamaica and Barbados is a very similar approach to what we see in this current bill that is before us, the NSITT bill. But, Mr. Deputy Speaker, if you look at the context of the operationalizing issues and the separation of powers, if you were to use that term with respect to their Director General and their minister and their board members, you see, Mr. Deputy Speaker, that there are a lot of issues that exist in those countries because of these deficiencies in the law. And that is why the CARICOM Model Bill was proposed and put forward for member states to consider and also apply it in their own jurisdictions so that it will be able to strengthen the independence and transparency that we want to see in the NSITT. Mr. Deputy Speaker, two areas, and I recall the member for San Fernando West spoke about Australia and spoke about the United Kingdom. But this government, Mr. Deputy Speaker, is a touch-and-go government, because the Honorable Attorney General, while mentioning Australia, while mentioning the United Kingdom, did not go into the fundamental differences that is contained in this bill compared to their legislation in those countries. All the honorable member said is that they did take a look at it, but again, no fleshing out of the issues here. Mr. Deputy Speaker, in a few minutes, I would like to take that opportunity to flesh out what are some of the areas that we can benefit from the Australian law and the UK law, and which I believe that the Joint Select Committee could consider while they are performing their work and deliberating on this particular bill. Mr. Deputy Speaker, you see in Australia, the Governor-General appoints the head of the Statistics Institute. There's an advisory council in Australia who feeds back to the head of the Stats Institute and the minister. Now, Mr. Deputy Speaker, in terms of the decision-making, the head of the Stats Institute in Australia is the one really who has the final say, because they are totally insulated, even though that there is some role for the minister. However, because of the protections afforded in their legislation, the role is a very limited one. Mr. Deputy Speaker, if you look at the United Kingdom, and I found this to be particularly interesting for members to take a look at, and I'm hoping that members on both sides will advance a lot of the work that has been done by the UK in this regard. Because, Mr. Deputy Speaker, there's a parliamentary oversight committee in the UK that deals with this specific matter of stats. And, Mr. Deputy Speaker, a situation arose in the United Kingdom where they themselves had to establish a separate committee from the oversight committee to assist them in furthering the work, because a lot of issues were creeping up with respect to privacy rights, with respect to proportionality, with respect to persons bringing legal action before the Stats Commission in the United Kingdom, Mr. Deputy Speaker. Mr. Deputy Speaker, in the United Kingdom, the Crown, the Queen appoints a chairman or the head of the Stats Institute. And the minister appoints the board members. And as I said, in several different jurisdictions, there is a variance. But I'll tell you what is the fundamental point contained in why the minister is allowed to select the board members. You see, Mr. Deputy Speaker, after that appointment, the minister has no function, no role, no responsibility, no interference. And that is safeguarded in the laws of the United Kingdom, Mr. Deputy Speaker. The minister must consult the chairman before appointing board members. Again, giving that power to an independent authority. And, Mr. Deputy Speaker, you will be familiar with the US system where you have congressional hearings and so on, and this person has to appear and be questioned. They have background checks, etc., to ensure that there's trust, faith, and confidence in the performance of the duties by the head of the Statistics Institute of the United Kingdom. Mr. Deputy Speaker, in the UK, the Office of National Statistics reports to the Parliament of the UK. It does not report to any minister, Mr. Deputy Speaker. Mr. Deputy Speaker, if we truly want transparency and integrity in the process, members opposite will support a system like this when it goes to the Joint Select Committee, where the Parliament has the oversight made up of members from both sides of the House, listening to submissions, work done in the interest of the people of Trinidad and Tobago, similar to like the interest of the people of the UK, by having a committee set up in the Parliament to deal with the reports. Mr. Deputy Speaker, with this oversight committee of the Parliament, the minister, as I said, has no involvement. Further, the board, as mandated by subsection 1, clause 27 of the Statistics and Registration Service Act of 2007, must lay an annual report in the Parliament outlining the following. A, what it has done during the year. They must categorize by class, by organizations, by individuals, the work that they have done during the year. B, what it has found during the year, the findings. Again, by class, by organization, by individuals. C, what work it intends to do during the next financial year. And Mr. Deputy Speaker, again, this bill, as it is totally deficient with respect to looking forward in terms of how we could add further developments when it comes to the transparency and faith and trust and confidence in the statistics and data that will come out from the NSITT. Mr. Deputy Speaker, a report mechanism through laying an annual report should be included and should be considered when it goes to the Joint Select Committee. This is something, Mr. Deputy Speaker, that should be done in conjunction with a parliamentary oversight committee similar to that of the United Kingdom. And we often talk about first world countries and wanting to advance and progress. And we have seen time and time again in this country where independent state institutions have been undermined by this government. Mr. Deputy Speaker. Mr. Deputy Speaker, that is in the DNA of the People's National Movement. We have seen it happen from the judiciary all the way up. And Mr. Deputy Speaker, this is another argument and another reason why when it goes to the Joint Select Committee, we will support a parliamentary oversight committee and a laying of an annual report when it comes to the National Statistics Institute of Trinidad and Tobago. As I said, Mr. Deputy Speaker, while we are advancing suggestions, we are not limited and constrained to only these suggestions, but other members from our side will listen to submissions provided by stakeholders in the industry, as well as research from their own experiences and other jurisdictions. Mr. Deputy Speaker, I want to turn your attention to some of the deficiencies, and I will come back to the UK system, Mr. Deputy Speaker. But I would like to look at some of the deficiencies contained in this bill with respect to the overview, Mr. Deputy Speaker. And Mr. Deputy Speaker, many stakeholders have had some say, whether it is through the media, whether it's through submissions to the ministry, because this bill has, while the bill may be relatively new, the work has been ongoing for some time. Mr. Deputy Speaker, we need to urgently update our income inequality index, also known as the Gini coefficient. There are huge inequalities in how our nation's wealth and income are distributed, which is why poverty levels continue to grow even after the economy earned windfall gains from oil and gas in the past. The last Gini coefficient available for Trinidad and Tobago, Mr. Deputy Speaker, you know, is from what year? 1992. Mr. Deputy Speaker, this is something that I would really like to see while the Joint Select Committee continues its work, that we put in place right here in Trinidad and Tobago, because we really cannot measure the prosperity and gain from different sectors as opposed to how it is trickling down to the everyday man and woman on the street, Mr. Deputy Speaker. And again, since 1992, we have not dealt with this issue. We also need to create an index that measures economic loss due to climate change. This will indicate how much economic activity suffers due to flooding. And Mr. Deputy Speaker, we saw the massive floods in Trinidad and Tobago. We saw the poor response from the government, Mr. Deputy Speaker. And again, government has not demonstrated through the Ministry of Planning and Development their commitment to dealing effectively with climate change and legislation and the treaties that Trinidad and Tobago has signed on to. The member for Naparima time and time again has raised that particular issue in this House. Where are we as a country with respect to that particular issue, Mr. Deputy Speaker? Mr. Deputy Speaker, as another deficiency, we also need an underemployment statistics, which will indicate the degree to which persons are employed in jobs that are far below the skill and educational levels. Such a university graduate working as a cashier in Subway, where you have doctors working in supermarkets. That is the reality of the situation that we have in Trinidad and Tobago. We cannot ignore it, Mr. Deputy Speaker, and that is one of the deficiencies that currently exist at the CSO, and that what we must look at in terms of the creation of this NSITT. You see, Mr. Deputy Speaker, I'll tell you this. We could have a very good working system if we get this right. But the history of this government and the history of their party has always been that while the intention may be there, you need to put the hard work in order to see the results. And Mr. Deputy Speaker, this is one of the areas of underemployment statistics that must be looked at with respect to the NSITT. Because you have a situation in Trinidad and Tobago where many graduates are unemployed or underemployed. Mr. Deputy Speaker, you would recall in this very parliament, the first budget of the member for Diego Martin Northeast, that they will establish the graduate trainee program in every ministry. Today, the graduate trainee program has been removed from several ministries and still cannot get its way off the ground.
This bill is about statistics and structures, not the fact of the statistics.
Member, proceed, but tighten quickly.
Thank you, Mr. Deputy Speaker. Mr. Deputy Speaker, it was just an attempt to demonstrate one of the areas that the National Statistics Institute of Trinidad and Tobago must be looking at and the deficiency in the current circumstance of the CSO. Mr. Deputy Speaker, we need to develop a financial stress index for the overall country. Many other jurisdictions, many other countries, they have established a similar index that assists in terms of the push and pull factors that has an effect on the economy in terms of whether it's dipping or whether or not it is improving. Mr. Deputy Speaker, all government ministries should have a performance index at the end of each fiscal year and feed back that information to the CSO. Well, now the National Statistics Institute of Trinidad and Tobago to rate their performance. That way, the government can be held accountable for underperformance and not meeting set targets. Again, in many other jurisdictions, this is something that is placed in their legislation, and it works well there, Mr. Deputy Speaker. Mr. Deputy Speaker, cybercrime and attacks does not receive proper attention locally. While I know that there is a Joint Select Committee dealing with this, we also need an index that measures the extent to which this occurs. All these things, Mr. Deputy Speaker, none of these things were spoken about when the member for San Fernando West and the member for Diego Martin Northeast, and it tells you the very myopic approach. I remember the member for Caroni Central in a previous dispensation spoke about these index and what it will do to boost confidence, but also to help measure the performance of the economy. And when the member for Diego Martin Northeast says that they pull statistics out of their hat, should the member speak about indexes like these, indices, like these? If the member were to speak about indices like these, Mr. Deputy Speaker, then we would not have the problems that we have today. But again, a very myopic approach, both from the member for San Fernando West. I will not chastise him too much because he's not the line minister. Minister for Planning and Development is not here today. But also the member for Diego Martin Northeast did not deal with any of these issues. We also need, and I know the member for Chaguanas West would appreciate this one, we also need a water crisis index for each locality to gauge the extent to which citizens are having access to clean, portable water. There's no mention of these sectors in terms of what the legislation provides for, but more importantly, what the work of the NSITT will be about. Mr. Deputy Speaker, Education Effectiveness Index to gauge how well students who receive GATE are contributing to productivity. The member for Tabakit, I know, champions quite a lot about the investment and the productivity. And again, Mr. Deputy Speaker, these are areas that the NSITT should be looking at. Mr. Deputy Speaker, the member for Diego Martin Northeast spoke about, the member for Diego Martin Northeast spoke about the United Nations Fundamental Principles of Official Statistics. And it was also mentioned in passing by the member for Caroni Central. Mr. Deputy Speaker, and I'm hoping government will be able to answer this in their wrapping up before the bill goes to the JSC. While some of the principles of official statistics, the report, was considered, how much of it was actually implemented in terms of the creation of the bill and in terms of the policy from the government? We are told that the policy was passed in the cabinet in December of 2016. How much of these United Nations fundamental principles of official statistics, which guides the creation of national statistical institutes around the world, have informed this particular bill? And again, it is something for the Joint Select Committee to work at. So there are two deficiencies with respect to international organizations and, well, also regional organizations. The United Nations and the CARICOM, as it relates to the CARICOM model bill. The United Nations fundamental principles of official statistics, Mr. Deputy Speaker, dealt with the following areas. And again, I am not comforted that when I take a look at this bill, that it clearly deals and considered all of these elements that would make up a fully functional National Statistics Institute of Trinidad and Tobago. It deals with relevance, impartiality, and I'm quoting from the United Nations Fundamental Principles of Official Statistics Implementation Guidelines. It deals with the relevance, impartiality, and equal access, professional standards, which was mentioned in passing, scientific principles and professional ethics, accountability and transparency, prevention of misuse, sources of official statistics, confidentiality, the legislation itself, national coordination, use of international standards, international cooperation, and most importantly, how to ensure independence. Mr. Deputy Speaker, the implementation guidelines of the UN speaks about the fundamental principles of official statistics being a pillar of the global statistical system, and that is accepted worldwide. But it is enshrined based on the profound conviction and commitment that official statistics have to adhere to well-defined professional and scientific standards. They define us as a professional community reaching across political, economic, and cultural borders. They have stood the test of time and remain as relevant today as they were when they first adopted over 20 years ago. And even though they would have been adopted 20 years ago, Mr. Deputy Speaker, the member for Caroni Central spoke about the different editions because there's a continuous updating to meet the demands of an evolving world with respect to the implementation guidelines. Mr. Deputy Speaker, in order for the principles to be more than just a statement of noble intentions, the UN says we need to renew our efforts individually and collectively to make them the basis of our day-to-day statistical work. Implementing them in our national institutions and systems is our common challenge. In this respect, much has been accomplished in the past 20 years, but much still remains to be done. It is in the spirit of shared responsibility that these implementation guidelines were produced. And Mr. Deputy Speaker, I don't think it is a surprise for many to hear, but one of the challenges that we've always had as a country is the issue of implementation, and the UN laments that there must be measurable elements in our legislation to tell us whether it is working or whether it is not. Mr. Deputy Speaker, there are a few other points before I wrap up that I would like to raise. And one of those issues is with respect to the performance evaluation of the Director General. Again, this is another deficiency. While it does provide, Mr. Deputy Speaker, for the Director General to return should he be accepted by the board and the process as exists now in this bill, which we do not agree with, it also is deficient when it comes to the performance evaluation. You see, Mr. Deputy Speaker, one of the guidelines of the UN Fundamental Principles of Official Statistics is appointments of persons to head these institutes or that will carry out the work of the institutes. And therefore, if we are defining clearly the roles of the Director General, the core responsibilities and functions of the Director General, Mr. Deputy Speaker, if the Director General has to be reappointed after the term, I'm not sure whether it is in the South African or the UK model Attorney General, but I saw where they also limited the terms of the equivalent to the Director General. And that is something that we may wish to consider as well. But most importantly, to put into our legislation a mechanism that will specifically address the area of performance evaluation. This has nothing about merits and benchmarks, etc. Therefore, it is in total contradiction to the implementation guidelines. And I don't know if the member for Diego Martin what he's really read or he just skimmed it. Because the member comes time and time, he says they do not read. Clearly, Mr. Deputy Speaker, I know it is a voluminous document, but the member for Diego Martin Ortiz should have known better and should have read the guidelines in terms of how it is applied and also the contradiction that it has with respect to the same bill that he got up to support today, Mr. Deputy Speaker. Mr. Deputy Speaker, the issue of privacy, and I know the Honourable Attorney General touched a bit on it with respect to the entry, whether it is through collecting data for census. And the legislation says, as it is before us, it gives the power and authority between the hours of 7 a.m. to 7 p.m. for entry. Mr. Deputy Speaker, when I spoke about the UK system, it is because the UK system has developed problems within itself in that the issue of privacy and privacy rights and the issue of proportionality has arisen before that committee. And the work of that committee is ongoing, but there are recommendations coming out of that committee of how we can deal with it. You know, I was having a chat with the member for Faizabad earlier, and I understood when the member for San Fernando West said, we have to understand the context of Trinidad and Tobago with respect to the establishment of the National Statistics Institute of Trinidad and Tobago. And Mr. Deputy Speaker, while I throw out these suggestions, I understand those realities, and it is not a pie-in-the-sky dream where I think, well, you know, our technology is so advanced and Trinidad and Tobago is a first world country that we could implement many of them. But I think what it helps us to see in the UK system is that 10, 15, 20 years from now, what some of the problems will be. And Mr. Deputy Speaker, we always say that we do not legislate only for today, but for further down the road, for other governments, for societies that have evolved, Mr. Deputy Speaker. But one of the challenges that they have found is that persons are objecting in the UK to the entry to conduct their census and so on, and it has the issue of privacy rights and proportionality has come to the forefront. And Mr. Deputy Speaker, some of the ways that they have been looking at it is that especially with the taking of the census, and again, the member for Faizabad told me, he said, oh boy, you know, people, I myself, the member for Faizabad is saying, I myself may be afraid for persons to come into my home to take this census considering the high crime rate and so on. And Mr. Deputy Speaker, what they have done in the UK is that they have recommended that we utilize the schools and communities where you establish staff and a resource base where persons can come in and then you protect within the law the information that is being provided by saying, listen, if you provide false data, that there will be sanctions and there will be penalties. Again, Mr. Deputy Speaker, it is some ways in which we should be looking holistically.
Member, you have 2 more minutes. Thank you.
Which we should be looking holistically at the evolution of the National Statistics Institute of Trinidad and Tobago. Mr. Deputy Speaker, in the few minutes that I have, I would really like to congratulate the member for Siparia and the member for Caroni Central for their leadership. Because when the Minister of Finance said that nothing was done, the mere fact that the Minister spoke about the report of 2014, I'm not mandated to say anything, like the member of for Sani Grande is speaking about, Mr. Deputy Speaker.
Please.
You see, Mr. Deputy Speaker, I am not promoted and then demoted. We stand on very strong ground here. When we go to a ministry or we go to an office, we have work to do. That is why we have delivery, and that is why we have performance. Mr. Deputy Speaker, we have done a significant amount of work. We are happy to see that Trinidad and Tobago will establish a National Statistics Institute of Trinidad and Tobago. But we must get it right. We will not just blanketly support what has been provided here. This is the work, the bill itself, the work that was done to inform the bill, Mr. Deputy Speaker, is not totally reflected in this bill. This bill reflects a lazy government, Mr. Deputy Speaker. It represents a government with a very myopic approach. And it represents a government who is desperate, Mr. Deputy Speaker, who is in desperation mode and continues to blame rather than deliver. Mr. Deputy Speaker, I will not be surprised if it takes the member for Caroni Central and the member for Siparia to come back to establish the National Statistics Institute of Trinidad and Tobago, because that is our modus operandi compared to what they have delivered, which is nothing from nothing is nothing.
I recognize the Attorney General.
Thank you, Mr. Deputy Speaker. My learned friend from Princestown gave a spirited
members.
contribution, full of sound, full of fury. But let's get to the facts so that we can judge the depth of the vessel that contained the contribution. Mr. Deputy Speaker, I want to start off with the honourable member's attempt, that is the honourable member for Princestown, to chastise the member for Diego Martin Northeast, and went on to quote an article that supposedly gave information coming from the Parliament. You see, the member went on to say that the member for Diego Martin Northeast, the Minister of Finance, was cherry-picking, he said. And while I sat here, one of my colleagues sent me a little message to just go online and take a look for the article that the honourable member is quoting from. So the honourable member goes on to say that the Minister of Finance is cherry-picking in his commentary, reads out content purported to demonstrate that cherry-picking.
Silence, members.
And here is what the www.guardian.co.tt news says. Listen to the headline online. Tiwari tells Senate, political interference at CSO by last government. Trinidad Guardian. So let's start off with the fact that the header on the World Wide Web is demonstrative that the argument put forward by the member for Princestown holds no water at all. But it doesn't stop there. It doesn't stop there.
1 second. Hello, 1 second. No, 1 second. Princestown, you had your opportunity, and I think you did well in terms of not being disturbed by anyone. So please, I'm not going to tolerate no disturbances. Proceed.
Thank you. So let's go a little bit further, because the art of advocacy is certainly to tell the version of the story that you wish to be convincing. I can't say anything other than Princestown did his very best. When we go to the fact-checking on the World Wide Web, and you start off with the header of the article as put forward by the Guardian itself, it demonstrates that what the honourable member put forward is far from what he put forward in the context of the manner of that story. Let's go into the article for IMF allegations. I'll call it that.
Which is not Tiwari.
So, in the IMF's 2014 Article 4 consultation, it is reported, and I quote, data shortcomings have reached critical mass and are now severely constrained staff's ability to conduct economic surveillance. The Central Statistics Office, CSO, temporarily ceased operations in mid-2013 and now operates under, and listen to this is in bold, in capital letters, in the report of the IMF itself. Not the Minister of Finance, not the member for Diego Martin West, not the Minister of Health, not the member for Caroni Central. This is the IMF choosing in an international publication to capitalize the words, and listen to them, and now operates under, capital word, extreme resource constraints, leading to very long lags for GDP, trade and labor data. Official trade data are available up to February 2012, while the GDP data for 2012 is still only provisional. There are significant gaps in tourism statistics, while expenditure side and quarterly GDP estimates that are flawed due to methodology weaknesses.
Minister of Finance and Chief Whip,
now,
please.
Mr. Deputy Speaker, I want to remind that in the review of the economy published under then Minister Larry Hawaii, year on year, we found the footprint of the People's Partnership. They actually bothered, as I welcome Madam Speaker back to the chair, they actually went so far in those statistics to put the letter P in the review of the economy. And you know why? Exactly, because it was provisional. year after year after year. The figures that Trinidad and Tobago was relied upon were provisional figures. And Mr. Deputy Speaker, we have to hear from Princestown, who has now fled the chamber, that this government is a government effectively to have no credibility from his perspective. Mr. Deputy Speaker and Madam Speaker, I think it infradig for one to accept the logic of Princestown, and I wish to wholeheartedly reject it. And I do so as I answer in final way on that particular point by quoting from the IMF again. This is what the IMF says. This government has recognized how critical data is for planning and mobility. The IMF in its Article 4 consultation in 2017, Madam Speaker, the IMF stated as follows. This is their 2017 report. The CSO has made noticeable, in capitals again, improvements in the timelines of data provisions since 2015. I mean, Madam Speaker, for Princestown to try to allege that the improvements that we're seeing in the CSO office came about as a result of the work purchased by the now frequently absent Siparia. I think I've seen her once for the year, if so lucky, in the sittings that we've had. And for the member for Caroni Central, I acknowledge the member for Caroni Central served as the functional minister in charge of planning, and I'm sure he would have done his work. But to say that this report from the IMF is attributed in the manner offered by Princestown, I think falls far short of the truth, Madam Speaker. Madam Speaker, I'd just like to say that if we are to accept the logic of Princestown, Princestown says that everything that is now bearing fruit is born on the back of the work of the United National Congress. My friend from Oropuch East thumps the desk, as he's entitled to. I invite them to accept that that is their reality, because to do so means you also have to accept that the crash in the economy, the savagery to the treasury, the removal of money from the taxpayers' hands in this country are also equally within their production, Madam Speaker. You see, you can't approbate and reprobate. You can't cherry pick, as Princestown invites. Either you accept it all or you accept none of it, Madam Speaker. And I think that that just simply answers the case. I want to go on to say that the observations coming from Caroni Central were very sensible observations. I think, yes, they were. I think that the observations and the questioning and the line of reasoning offered by Caroni Central take us to one end of the spectrum. After all, much of the logic offered from Caroni Central can be found in a precedent. That precedent, albeit not on point, is the public procurement legislation. In the public procurement legislation, there is a swing in the scale of proportionality where the executive intervention via the minister or cabinet, labeled as president, is minimized by president upon consultation, etc. Those methodologies can be discussed certainly at the Parliamentary Joint Select Committee, but the core content of what my learned colleagues have offered are really not difficult issues. Yes, we can insert an objectives clause. It's in the public procurement. It's in clause 4. It's a very simple clause, not a difficult position. The objects set out, forgive me, it's not clause 4, it's in clause 5. We could easily have adopted a little, the objects of the Act R2, and then you go through A, B, and C, very short reference. That's permissible. The danger in doing that at times really revolve around claims for review purposes, in particular judicial review, and whether one is ultra vires or not. So a cautionary approach is usually done by just sticking to the functions of the entities. The treatment of the ministerial intervention in this, again, it is the existing law. In the existing Statistics Act, we have the role and the appointment functionality coming from central government. I'm not necessarily persuaded that the CARICOM model is the quintessence of legislative perfection. Very often, one is reminded that the CARICOM model, as applied in other CARICOM territories, operates with every other CARICOM jurisdiction having a very different constitution from ours. Our Republican Constitution, Madam Speaker, has an entrenched provision to deal with Trinidad's dichotomy. Trinidad and Guyana are the two societies that fought two national entity contributors, our ancestors, those from Africa, those from India, that have managed constitutional reform in the case of Guyana with a very interesting constitutional arrangement for presidency and National Assembly, and in Trinidad and Tobago, on the basis of constitutional entrenchment, supposedly then to make sure that we protected our delicate balance of our racial operation. And I say that not only from my pursuit of education in this country, but from the mouth of my own grandfather, who went to Marlborough House and participated in the constitutional arrangements for Trinidad and Tobago, and who, by his own report to me, had a very sincere fight with Capilio over the insistence to entrench the protections that we have in our Constitution. My grandfather's submission then, he as member for Naparima, Lord rest his soul, with who is now occupying the seat of Naparima, but the contribution then was that Trinidad and Tobago would come into difficulty 50 years later because of these provisions. So when we look at the CARICOM model, I'm not persuaded that just because CARICOM has it, we ought to follow it. Jamaica operates in the passage of laws in a way that Trinidad and Tobago can't even get over because of our constitutional entrenchment provisions. And for the record, we did consider, and I did call out in the heading analysis of jurisdictions, that we had looked at CARICOM model as well. We did look at the CARICOM model. I put that onto the record. But it is not everything that passes across your desk is a great idea. It must be looked at in the context of Trinidad and Tobago. And for that reason, I offer caution to Princestown in particular, that that model is necessarily the best model. This particular bill is something that we always intended would come to Joint Select Committee. I think we are in agreement that the national statistics ought to be operated upon. I don't want to be pejorative unduly this afternoon, so forgive me for having been compelled to answer the submissions of Princestown in the manner that I have. But I want to say, I think this is within our grasp. If we look to the core of the bill, the general provisions are really the heart and soul of the 3/5 issues that we're looking at, the right to entry, the right to privacy, that can be managed by due processing and other protections. The aspect of ministerial or executive intervention, we have models of that right here in Trinidad and Tobago. The public procurement law is certainly a model that we can look to and can be guided by. I think that this is work which we can easily take to the public procurement desk analysis. We can look at the CARICOM models and provisions. I am confident that we can, in the committee's work, get through this. It's not complicated law. And Madam Speaker, I look forward to the work of the Joint Select Committee as we get there. I thank honourable members for their contribution, and I beg to move.
Honourable members, the question is that a bill entitled An Act to Repeal and Replace the Statistics Act, Chapter 1902, establish a National Statistical Institute of Trinidad and Tobago, and for other related matters, be now read a second time. All in favour say aye. Aye. Any against? The ayes have it.
A bill entitled An Act to Repeal and Replace the Statistical Act, Chapter 1902, established in National Statistical Institute of Trinidad and Tobago, and for other related matters.
Attorney General.
Madam Speaker, I beg to move that in accordance with Standing Order 68-1, that a Joint Select Committee be established to consider and report on the National Statistical Institute of Trinidad and Tobago Bill 2018, and that the committee be mandated to report by the 31st of March 2019.
Honourable members, the question is that a Joint Select Committee be established to consider and report on the National Statistical Institute of Trinidad and Tobago Bill 2018, and that the committee be mandated to report by the 31st of March 2019. All in favor say aye. Aye. Any against? I think the ayes have it. Attorney General.
Madam Speaker, subject to the concurrence of the Senate on the establishment of this committee, I beg to move that this House appoint the following 6 members to sit with an equal number from the Senate on the Joint Select Committee established to consider and report on the National Statistical Institute of Trinidad and Tobago Bill 2018. Mrs. Camille Robinson Regis, MP, Mr. Terence Dialsing, MP, Mr. Randall Mitchell, MP, Mrs. Sherian Critchlow Coburn, MP, Dr. Boindradat Tiwari, MP, Dr. Tim Gopi Singh, MP.
Honorable members, subject to the concurrence of the Senate on the establishment of this committee, the question is that this House appoint the following 6 members to sit with an equal number from the Senate on the Joint Select Committee established to consider and report on the National Statistical Institute of Trinidad and Tobago Bill 2018. Mrs. Camille Robinson Regis, MP, Mr. Terence Dialsing, MP, Mr. Randall Mitchell, MP, Mrs. Sherian Critchlow Coburn, MP, Dr. Boindradat Tiwari, MP, and Dr. Tim Gopi Singh, MP. All in favor say aye. Aye. Any against? I think the ayes have it. Attorney General.
Madam Speaker, I beg to move the following motion standing in my name. That is motion number 2. Be it resolved that the Senate amendments to the Administration of Justice Indictable Proceedings Amendment Bill 2018, listed in the appendix on the supplemental order, be now considered.
Honorable members, the question is that the Senate amendments to the Administration of Justice Indictable Proceedings Amendment Bill 2018, listed in the appendix on the supplemental order paper, be now considered. All in favor say aye. Aye. Any against? The ayes have it.
Clause 3, in paragraph A, Roman numeral 1, insert after the definition of arrest warrant the following definition. Computer means a device or group of interconnected or related devices which follows a program or external instruction to perform automatic processing of information or electronic data.
Attorney General.
Madam Speaker, may I ask whether it is the will of the House that we take all of the amendments in the round, insofar as there are only a few of them?
Is there agreement?
Yes. Clause 4, in paragraph C, A, in subsection 6, insert after the words under this section, take the word all. B, in subsection 7A, insert after the word suspect the words or his authorized representative. And C, in subsection 8, insert after the words or a suspect the words or his authorized representative. Clause 8, in subsection 5A, by inserting after the words notice to be the words filed in the High Court and by deleting the words and filed in the High Court. Clause 13, in paragraph A, by deleting the word 10 and substituting the word 28. Clause 24, renumber the existing paragraphs A and B as paragraphs B and C respectively, and insert a new paragraph A as follows. By inserting after the words file an indictment the words under section 6.2. Clause 27, in paragraph 7, by deleting the word 14 and substituting the word 28. New clause 29, insert after clause 28 the following new clause, section 33 amended. 29, section 33 of the Act is amended. A, in the marginal note, by inserting after the words chapter 1201 the words Act number 14 of 2014, and B, by deleting the word is and substituting the words and the indictable offenses committal preceding Act 2014, and renumber existing clauses 29 to 31 accordingly.
Attorney General.
Thank you, Madam Speaker. Madam Speaker, I'm very pleased to give the rationale for the Senate's proposed amendments to this bill, which is a bill to amend Act number 20 of 2011, that being the law by which we propose to abolish preliminary inquiries in Trinidad and Tobago. The first amendment is an amendment to the definition section of Act number 20 of 2011. We propose in Clause 3 of the bill to introduce a definition of the word computer. We do so modeling the definition for computer from two particular pieces of law. Firstly, the Anti-Terrorism Act, and secondly, from a bill which we have in Joint Select Committee to treat with cybercrime legislation. We thought it prudent insofar as we were allowing for search warrants in respect of computers to have a defined term as opposed to an undefined term as prevailed in the 2011 legislation. The second amendment, Madam Speaker, is to Clause 4A. We seek to insert the word all. Now, Clause 4A, as it appears in the bill, is the clause intended to be treated with in subclause 6. And this is where, Madam Speaker, we are treating with the execution of a search warrant that a constable shall do certain things, and then we say in relation to that which is seized, we had provided in subclause 6 that a person shall, during any period that he is assigned responsibility for the safekeeping of anything seized under this section, take reasonable care. Now we're providing take all reasonable care. This was intended to give a slightly broader or weightier obligation upon the custodian of evidence to ensure that evidence, firstly of the kind that is to be produced by the prosecutor, is in fact brought forward, and secondly, evidence of the kind that can be subjected to a claim for detenue or for compensation insofar as evidence may deteriorate. Take the example of a motor vehicle which is seized and it was not kept in proper care and condition in the police custody. We felt it important to convey Parliament's position that there should be a slightly more diligent management of evidence, both for production in the courts from a prosecutor's point of view and for protection of the evidence from a wastage point of view or a wasting point of view, as that concept is used in law. We have also in this clause sought to add in subclause 7 a safeguard. Now, subclause 7 of the same 4E treated with the identification of matters which were put into evidence, things which were seized. We have allowed for the first time the photographs of evidence seized to be taken so that you don't need to continue in possession with the thing for years in some circumstances where the trial can be inordinately long. We thought it prudent to catch the situation where a suspect who was not available, perhaps through incarceration, would not be present together with the Justice of the Peace to certify the photograph, and therefore we've allowed for the inclusion of the phrase or his authorized representative, being hinged specifically to the suspect so that we have a better due processing, so that his authorized representative, be it agent or legal representative, could be there to treat with it. Similarly, in subclause 8 of that particular, again, clause 4A, we have added in that as a further safeguard as well. Madam Speaker, we turn to clause 4, which amends sections 5, 7, and 8 of the Act. Forgive me, that's the one that I just spoke to. I had mistakenly called it 4A, it was 4. I'll turn next to clause 8, which amends section 8, capital A. And if we look to that provision, as we get to 8, capital A of the Parent Act, and we look into the bill, we're seeking to insert the appearance before magistrate prescriptions. We have added in just a simple reversal of language. The original bill required where the magistrate made an order that the notice to the registrar shall specify the offense, and the magistrate shall cause. Originally we had a copy of the notice to be served on the accused and then filed in court. In fact, it should have been the other way around. You file it in court, and that which has been filed is then served upon the accused. So that's the simple amendment to Clause 8 of the bill. We then seek in Clause 13, which amends Section 13 of the Act, to increase the time for the provision of an alibi. And we did that, Madam Speaker, just because of the realities of Trinidad and Tobago's litigation. We felt it prudent to improve the time frame away from 5 days and instead to 20 days for the service. So that is the amendment to Section 13 of the Act, which is by Clause 13 of the bill. Madam Speaker, I turn next to Clause 24, which seeks to amend 27 of Section 27 of the Act. And if we look to Section 27, this is a very important provision that allows us to have the circumstances of the DPP's ability to avoid a sufficiency hearing, in particular in complex fraud cases, as exists under Section 23 of the Indictable Proceedings Act, Chapter 1201 in any event, but very importantly in circumstances where the trial of the accused has been aborted for any other reason. We accept the dicta of Madam Justice Gobin in the case of Marcia Caesar matter most recently, now at an end, which provided that de novo is not an appropriate circumstance to return cases. And in these circumstances, we're allowing the DPP to move straight to an indictable position. We thought that the clause needed a small tidy up because it was not clear that we had looked at the circumstance of the DPP's referral under Section 6.2 of the Act, and therefore, by way of clarification, we've inserted that into Section 27, subclause 2, which is what Clause 24 treats with, to provide for a clarification of the reference of getting there. I turn to Clause 27. 27, again, we're looking at just simply the time frame. Clause 27 amends Section 30 of the Act, specifically Section 30, subclause 7, to increase the time for which the DPP is to provide the names of witnesses to the registrar from 14 to 28 days. We've harmonized that procedure, obviously, in the reverse for the accused to provide, etc. That already stood in the law, but we just simply amplified the time frame from 14 days to 28 days. We've added in an omission. In treating with the bill in this House, we had inadvertently omitted, and I've checked since then, to deal with the fact that this 2014 law, the Committal Proceedings Act, was in fact assented to. Having confirmed that it stood as law, it is necessary, therefore, to repeal it as we revert to the 2011, now improved version of the abolition of preliminary inquiries. Madam Speaker, those are the reasons that arose in the Senate for these consequential amendments, and I beg to move.
Honourable members, the question is that this House agree with the Senate in the amendments to clauses 3, 4, 8, 13, 24, 7, and the insertion of a new clause 29 of the Administration of Justice Indictable Proceedings Amendment Bill 2018. Member for Princestown.
Thank you, Madam Speaker. Madam Speaker, with respect to the amendments made in the Senate in relation to an act to amend the Administration of Justice Indictable Proceedings Act 2011, before going in clause by clause to deal with some of the substantive issues and some of the concerns that we had, I would like to indicate at this point, as a student of law, I was very happy to take a look at the proceedings that took place in the Senate and some of the contributions that helped to strengthen the amendments that are before us. And also I want to thank Senators Ramdeen, Hussain, Vieira, Chote, Sobers, and also the Attorney General for accepting the recommendations coming out from that sitting. Madam Speaker, Clause 3 essentially amends the definition section of the Act. It included the definition of several terms mentioned in the Act, such as arrest warrant, documentary exhibits, either way offense, etc. However, the term computer, as the Honorable AG has said, it was inserted in bill at clause 4 for materials which are the subject of a search warrant. Madam Speaker, the bill was deficient in that it did not define what is a computer. During one of the contributions, Madam Speaker, the issue raised was that the term computer was not defined, and they found that a definition existed, as the Honorable Attorney General said, in the Anti-Terrorism Act, Chapter 1207, and as such, that was the definition that was accepted. Madam Speaker, one of the questions that I have really is not an argument to put forward, but a question really, and hopefully the Attorney General will be able to see, is that whether or not the amendment, when it was considered, whether or not the Honorable Attorney General looked at the model law outlined by the OS and the Commonwealth with respect to the definition on this particular matter. Honorable AG, you would also remember that in 2002, there was a law ministers conference in Trinidad and Tobago. And since then, and it dealt with some of these substantive issues in terms of definitions, similarly that of a computer, etc. And while 2002 was a long way off to where we are in 2019, that law ministers conference, the reports have evolved since then. And I just wanted to have an idea of whether or not in putting forward this definition, whether that was actually considered. Madam Speaker, clause 4. In subsection 6 inserts after the words under this section take the word all. In clause 4 of the bill, introduced by the AG to make it clear that computers and electronic devices are subjected to a search warrant, it further allowed to the retention of the items seized and the filing of the report in the High Court of items that have been seized. The amendment at subsection 6 stated that a person shall, during any period that he is assigned responsibility for the safekeeping of any seized under this section, take reasonable care to ensure that it is preserved for the purpose of evidence in criminal proceedings. Madam Speaker, I'm a little bit concerned here because it says takes reasonable care to ensure that it is preserved for the purpose of evidence in criminal proceedings. I will develop on...
All we could really deal with here are the amendments. So we're not rehashing the whole thing, so that what you're dealing here with is either all suspect or his authorized representative. That's all.
Sure. Sure, Madam Speaker. Madam Speaker, with respect to this particular clause, one of the issues that we had in relation to this was that there is in common law, Madam Speaker, a case, Dylan Haynes versus the Attorney General of Trinidad and Tobago.
All.
Yes.
All, not the clause. It's not the entire clause. We had our opportunity here to have dealt with it. All we have to consider now is the all. Or, as I say, because I can't say whether you're dealing with A, B, or C, or his authorized representative.
Certainly.
That's all you could deal with.
Thank you, Madam.
All.
Madam, as such, it was suggested that greater emphasis should be placed in storing and keeping of the seized item by the police taking all reasonable care to ensure that evidence is preserved and not just reasonable care. Madam, the concern that we have with that with respect to police taking all reasonable care is that we have seen from time to time in our justice system where all reasonable care have not been taken. And you have had situations that...
Okay, go on. You've made your point, go on.
Thank you, Madam. Madam, with respect to... Madam Speaker, with respect to clause 8, by inserting afterwards notice to be the words filed in the High Court and by deleting the words and filed, and B, sorry, by deleting the words and filed in the High Court, B, by inserting after the words notice to be the words filed in the High Court and. Now, Madam Speaker, this section was introduced so that at the first hearing, the magistrate has the power to issue a notice to the registrar specifying the offence which will be transferred to be heard before a master, namely indictable offences, either way offences which are being heard indictably or related summary offences which can be tried together in the High Court with the indictable offences. The notice, Madam, which a magistrate issues to the registrar must be served on the accused However, the procedure as drafted was incorrect as it provided for serving the accused and then filing it in the High Court. Again, this could possibly have been an administrative error. Hopefully the Honorable Attorney General will be able to tell us whether or not this was an administrative error, and really the homework should have been done with respect to this.
Yes, when he made his presentation.
Sure.
Okay? Now remember, this process is just limited to these very little words.
Yes, madam.
Okay? So while I'm allowing you a little leeway to put it in context, we're not here rehashing a debate of the bill.
Certainly.
Good.
Madam, with respect to clause 13, and I do take your point and I appreciate it and I abide by your ruling. In clause 13, in paragraph A, by deleting the word 10 and substituting the word 28, I would like to say that when you look at other jurisdictions, Honorable Attorney General, we agree to this particular provision. I know this is something that Senator Ramdeen would have raised. When you look at the NYU and the Cornell University Federal Rules of Criminal Procedure, it suggested 14 days. In other jurisdictions in the Commonwealth, which we share similar jurisprudence with, it suggested between 14 and 28 days. I think this is a step in the right direction with respect to considering what is happening at the DPP's office, Madam Speaker. Madam Speaker, clause 24, renumbering the paragraphs, is really an administrative issue here, but it inserts after the words files an indictment, the words under section 6.2. Clause 24 amends section 27.3 of the Act. Section 27.3 allows the DPP to request a sufficiency hearing where he prefers and files an indictment without a sufficiency hearing. Therefore, to clear up any ambiguity, Madam Speaker, that existed, the Attorney General accepted the amendment by the opposition. We are very happy by that, and independent senators to state clearly what the indictment, which the DPP prefers, is from his powers derived from section 6.2 of the Act. We are very happy for that ambiguity being cleared up. Madam Speaker, with respect to clause 27 in paragraph 7, by deleting the word 14 and substituting the word 28, the section treats with the time limit given to the DPP to inform the registrar of the names of the witnesses he desires to call at the trial. Again, Madam Speaker, for those who practice in the system, they understand the limitations here in terms of the section that will treat with a time limit given to the DPP to inform the registrar of the names of the witnesses that he would like to call in a trial, and the plethora of issues that we have here. But, Madam Speaker, a further point is that if we are making greater demands on the DPP, therefore there must be greater resources available to the DPP, and not what we saw on the Express front page of Sunday.
Please go on to your next point.
Thank you, Madam. Madam, clause 29, section, this is the last one. Clause 29, section 33 amended. 29, section 33 of the Act is amended. A, in the marginal note, by inserting after the words chapter 1201, the words Act number 14 of 2014. And B, by deleting the words is and substituting the words and the indictable committal proceedings Act 2014R. This is an amendment by the AG, which is consequential in nature. The 2014 Act was assented and is on the law books. The Act would come into force with repealing the 2014 Act. As such, it is a consequential amendment. Madam Speaker, having gone through the amendments and attempting to make some issues of it, what I would say at this point as I wrap up, Madam Speaker, is that I do see merit in terms of the strengthening of the legislation that came back from the Senate, and I really would like to thank members who made those recommendations. I know the Honorable Attorney General, if you'd allow me, I know you did give an undertaking with some other areas of the law. I was very happy to see that, and I thank you, Madam Speaker.
I want to push the envelope today.
I'm done.
So I understand that. And, you know, we're in a very cordial spirit, so I understand that. Are you finished?
Yes, ma'am. Thank you.
Okay. Member for Caroni East.
Ask him whether he'd be kind enough to, Madam Speaker, thank you for allowing me to wear this because of my eye surgery. I appreciate it. I just wanted to ask the Attorney General, would you be kind enough under Clause 3 to give some examples of the devices, of interconnected or related devices? Give some examples, if at all possible. Thank you.
Madam Speaker, I thank both members for their contributions. By way of example, it really takes care of everything. It's intended to capture any device, a telephone, a computer, etc. We've used this modern version coming out of our work in a Joint Select Committee on cybercrime. I won't go into that work. And coming out of the best-in-class standard that we use in the anti-terrorism law. So we thought it prudent to stay with that definition as opposed to earlier definitions raised by the member for Princestown. But it is intended to be a law which continues to speak, meaning that the law will evolve as devices evolve. So we've gone for as non-technically specific definition as possible to allow the law to apply in those circumstances. I hope that suffices. I beg to move.
Honorable members, the question is that this House agree with the Senate in the amendments to clauses 3, 4, 8, 13, 24, 27, and new clause 29 of the Administration of Justice Entitled Proceedings Amendment Bill 2018. All in favor say aye. Aye. Any against? The ayes have it. Leader of the House.
Thank you, Madam Speaker. Madam Speaker, after a productive day, I beg to move that this House do now adjourn to Friday, 8th February at 1:30 p.m. when the House will debate a bill entitled An Act to Amend the Trespass Act, Chapter 1107. Thank you very much, Madam Speaker.
Honorable members, the question is that this House do now adjourn. All in favor say aye. Aye. Any against? The ayes have it. In accordance with Standing Orders 11 and 12.1, this House now stands adjourned to Friday, 8th February. Okay. We just have a few more seconds here. In accordance with Standing Orders 11 and 12.1, this House now stands adjourned to Friday, 8th February 2019 at 1:30 p.m.